Incoming voice call from Bikash Pal on SIM Geo. Incoming voice call from Bikash Pal on SIM Geo.
হ্যাঁ বলো। হ্যাঁ ইন্দ্রের সাথে কথা হয়েছে। হ্যাঁ কথা হয়েছে। না না আমাকে বললো গোটা ভিডিওটা রেকর্ড না। ঠিক আছে আমি দেখছি, তুমি যদি এমনি সুপ্রিম কোর্টের এই আমি ইউটিউব যে লিঙ্ক দুটো দিয়েছি দুটো ইউটিউবে, এই দুটো লিঙ্ক ছাড়া যদি কোনো লিঙ্ক থাকে আমাকে দাও তো। ওই লিঙ্কটা তো ওয়েব ম্যাক্স থেকে, ওয়েব ম্যাক্স থেকে ওই লিঙ্কটা তো তোমার ইউটিউবে শুনতে হবে না, ডাউনলোড করে ওয়েব ম্যাক্স ইনস্টল করে তারপর জয়েন করে ঢুকতে হবে। ডাইরেক্ট লিঙ্ক, ডাইরেক্ট লিঙ্ক। ইউটিউবের লিঙ্ক আমি দিয়ে দিয়েছি। হ্যাঁ ইউটিউবের লিঙ্ক আমি দিয়ে দিয়েছি, আমি ইউটিউব ছাড়া অন্য কোনো দেখছি আর কি। আচ্ছা আচ্ছা ঠিক আছে, আমি সকালবেলা ঘুম থেকে আমি শুয়েছি কাল 3:30, উঠতে পারিনি। হুম হুম।
True it. Ever heard of it? What if I told you you've been. Ever heard of it? What if I told you you've been. Ever heard of it? What if I told you you've been. Ever heard of it? What if I told you you've been. Ever heard of it?
এটি একটি অবাস্তব আইডিয়া।
আমার আর্মাস বিক্রি হয়ে যাবে। বাজারে অনেক মেটাল হেড আছে।
কিন্তু মেটাল হেড মানে তো এইটা নয়। হ্যাঁ,
তোর হেল্প লাগবে না, আমি একাই 100।
ক্যানভা ম্যাজিক মিডিয়ার সাহায্যে নিজের আইডিয়াকে সাজিয়ে তুলুন ছবি এবং ভিডিওর মাধ্যমে।
1150টা অর্ডারস। কেউ কি জেস্টারের জামাটা পরবে প্লিজ?
ক্যানভা মন থেকে ডিজাইন পর্যন্ত।
হ্যাঁ, 2017
not like to mention, Mullahs, but I have to. The reason is, Mullahs, there was a Bangalore Palace Acquisition and Transfer Act of 1996, upheld by the High Court through legislation with a compensation of 11 crore. Just Mullahs, a minute.
Send your letter.
No, he says I will not allow. That's why I'm giving the reason. So, Mullahs, 11 crores upheld, appeal pending since 2003. In the meantime, the government wanted to have a public road for which TDR rights have been given of 3,000 crores.
Just send a letter, we'll take the letter.
I've sent a letter. He says, because it's a civil appeal, I'll not allow you to. Because this
It's
is,
a pending matter.
yeah, it's 2003, since
Okay, fine.
97, Mullahs.
Send a letter, please. Send a letter.
Very obliged. We have to implement it in 6 weeks, the 3,000 crores.
Please send a
I've sent
letter
it.
of
I've
request,
Yes.
an email or a letter of request, that's all. Letter of request for
But in this, there are four category of employees. Second category is not-
Wait, let's start now.
Lordship, we need at least 2 days for this, you know.
Please, we'll see.
Very well.
We'll see.
My lord,
There is one batch of candidates who are untainted, selected, not found.
Please,
anywhere.
please,
So
please.
therefore,
Let's,
their selection-
let's not have piecemeal arguments. Let's
Very
start.
My lords would hear the state first and the commission first and.
I don't know, whoever wants to start, we can start.
Because we are students, we are the people who are.
One minute, please. We said on the last date also, you decide who wants to start.
The state has been starting, Manoj. Normally the state starts earlier.
Okay, fine, please do start, Mr. Singh. You're appearing for the state, I think.
No, I'm not for the state, Manoj. I'm saying the state has been starting. I'm for the untainted category.
Limited prayer, Millet. State has a limited prayer, Millet. We are the affected candidates. Therefore, Millet.
Okay, whoever wants, let the state start and then the others can start.
Let this written.
We would respond in advance, Lord, it's para 265. The state has admitted before the High Court that no segregation can be made. It is so colossal. That para 265 in the judgment is the
Okay,
admission of the state.
okay, please. Yes, please. You're preparing for the.
I'm appearing the state.
For state.
Because if your lordships has the order of this court, my lord, the data. 7th May 2024. That sets out, my lord, in some detail how the matter comes up.
Yes.
May I place this order, Milord?
Please do.
Paragraph 3, Milord. In 2016, the School Service Commission in West Bengal conducted selections for recruitment to 4 categories of posts. Assistant teachers for class 9 and 10, assistant teachers for class 11 and 12, non-teaching staff of the group C category, and non-teaching staff of the group D category. Notification for the state level selection test was issued on 16th February 2016. An OMR based written examination was held on 27th November 2016. The final panel for candidates for class 9 and 10 was published on 12th of March 2018. The merit list of empaneled candidates was published on 28th August 2018. Candidates joined as assistant teachers in or about January and February 2019. A batch of petition.
বাবা বলেছিলেন ইঞ্জিনিয়ার হয়েছি হাজবেন্ড তাও হয়েছি কিন্তু মূর্খ হয় এটা তো বলেননি এই দেখুন জাল পেমেন্টের এসএমএস, বলে কি বাবার থেকে নেওয়া ঋণ শোধ করছি, তারপর বলবে ভুল করে বেশি টাকা পাঠানো হয়েছে, বাবু বাকি টাকাটা ফেরত দে তো। আমি
Rules 2016. Likewise, there are rules governing the selection to assistant teachers for class 11 and 12 and also of 2016. The selection for Group C and Group D non-teaching posts is governed by West Bengal School Service Commission, Rules 2009. The writ petitions before the High Court were instituted in 2021. From time to time, interim orders were passed by the High Court annulling the appointments on the ground that appointments were made illegally. The appointments were assailed initially before the division bench of the High Court and ultimately the dispute traveled to this court. By its order dated 9th of November 23, this court held that the direction of the High Court for the termination of services of candidates at the interim stage, even before the final disposal of the petitions, ought to have been avoided. This court, while dealing with a batch of petitions directed in Achintya Kumar Mandal versus Lakshmi Tunga, that all the issues relating to the appointments of 2016 should be examined by a division bench of the High Court, and accordingly, an order of remand was passed. The issue of maintainability of the petition was kept open. The order of remand has resulted in the impugned judgment of the High Court. The High Court has held inter alia that all appointments made in the selection processes involved were violative of Article 14 and 19 of the Constitution and are therefore null and void. As a consequence of the judgment of the High Court, approximately 25,000 appointments would stand to be set aside. During the course of the hearing of the cases before the High Court, there was a direction to the Central Bureau of Investigation to conduct an investigation in regard to the alleged acts of criminal wrongdoing arising from the selection process. The order dated 9th November 2023 directed the CBI to complete its investigation within 2 months and to submit a report of the High Court. In the meantime, this court directed that the appointments which have been made shall stand protected for a period of 6 months to enable the division bench to adjudicate upon the matter. Before the High Court, as indeed before this court in the earlier proceedings, a fundamental issue which arose for consideration was in regard to the admissibility of the OMR sheet images which have been recovered by the CBI. The court noted that the investigation by the CBI has yet to be completed. The admissibility of the OMR sheet images being in question, this court observed that the question of the exercise of power in relation to discovery of electronically stored OMR sheets implicated serious allegations in regard to manipulation of records. Having regard to the number of persons who are likely to be affected by the outcome of the proceedings, it was considered appropriate to remand the proceedings back to the High Court for final decision on the writ petitions. Before dwelling further on the ultimate directions which have been issued by the High Court, it would be necessary to note at this stage that 3 reports were filed by the CBI after the remand of the proceedings. The impugned judgment of the High Court has dealt with the reports of the CBI. It would be necessary at this stage to make a brief reference to the report dated 5th February 2024, which is the final report which was filed before the High Court. The report of the CBI notes that the West Bengal School Service Commission had awarded a work order to a company by the name NISA Communications Private Limited for scanning and evaluation of the OMR sheets pertaining to the selection test for each of the 4 categories. The scanning of the OMR sheets was undertaken by the office of the SSC. It further emerges during the investigation that the company which was awarded the contract by the SSC had further assigned the work of scanning the original OMRs to an entity by the name of Data Scantech Solutions Noida, which was present at the premises of SSC for completing the scanning work. According to the CBI, after completing the scanning, the processed data in the form of scanned images of OMR was handed over by Data Scantech to NISA Communications in the digital form, leaving the original hard copies of the OMR sheets in the office of the SSC. According to the CBI report, the SSC handed over the answer keys for all subjects to NISA Communications Private Limited for evaluation of the OMR responses. CBI seized the server database of the SSC during the course of the investigation. On 15-16 September 22, 3 hard disks were recovered from the residence of a person by the name of Mr. Pankaj Bansal, a former employee of NISA Communications Private Limited at Ghaziabad. Certificates dated 19 September 22 under Section 65, capital B of the Evidence Act were obtained from Mr. Pankaj Bansal. During the course of the investigation, data files containing scanned OMRs, among other things, were seized from Data Scantech Solutions. The report of the CBI contains the following observations in para 12 and 13 of the report. Para 12, that a similar exercise of matching the data available on the hard disk of Pankaj Bansal with the data seized from the commission was done during the course of investigation, and it was found that there were mismatch between the two, inasmuch as the written marks awarded to candidates as available on the server of the commission had been increased to qualify undeserving candidates. This mismatch establishes that manipulation in marks of written examination in the case of many candidates was resorted to, and such candidates were identified. The comparison of genuine OMR marks with the OMR marks available in West Bengal Service Commission server shows that there is a manipulation in 952 numbers of candidates of class 9 and 10, 907 numbers of candidates of 11, 12, 3481 numbers of Group C candidates, and 2823 of Group D. That during the course of investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons and officials of NISA. These emails contained lists of candidates whose OMR marks were found to be increased in the server of the commissions. Besides these, the emails have been exchanged between the staff of NISA themselves, containing the manipulated data of candidates. This shows the complicity of officials of Mrs. NISA in this conspiracy. The above noted investigation by the CBI indicates that it has found a manipulation in respect of 952 candidates for the selection process of assistant teachers for class 9 and 10. In the case of 907 candidates for class 11 and 12, 3481 candidates.
This will indicate that the marks were increased when they were uploaded in the server compared to the written examination.
That's right. So.
That's all. That clarification is just, we wanted that clarification.
Yes. Apart from the above report of the CBI, the impugned judgments of the High Court contained in para 240 a reference to the fact that SCSC had submitted a statistical report of the 4 selection processes tabulating the alleged irregularities. The tabulation is reproduced below for convenience of reference. So, Lordship, see that with regard to assistant teacher, the irregularity percentage is 8.5. Assistant teacher 11-12 is 14%. It is larger in case of Group C and Group D. The High Court has also noted that in response to its queries, the SSC had submitted details of the recommendations which were made by it in respect of the 4 categories and the number of appointments issued by the board. The figures submitted by the SSC indicated that the actual number of persons who were appointed by the board was in excess of the recommendations made by the SSC to the following extent. Assistant teachers 1539, assistant teachers 912 199, Group D 669 and Group C 416. On the basis of the data which was submitted before.
Just 1 minute over here. The recommendations for Group D was that this is the enhanced number above that?
Yes.
That is enhanced number above the figure of, say, in the case of 11,610, 5596, 2037?
Yes. Yes, sir.
Okay.
Only for.
Yes, please. Continue.
And the SSC had submitted details of recommendations which were made by it in respect of the 4 categories and the number of appointments issued by the board. figures submitted indicated that the actual number of persons who were appointed by the board was in excess of the recommendations made by the SSC.
Okay.
So this is the another fault, my lord, that some more people.
Yes, please.
On the basis of the data which was submitted before it by the SSC, the High Court has observed in para 241 that the illegalities admitted by the SSC cannot be said to be within tolerable margins in a selection process of a large magnitude, and that the SSC itself did not discount the fact that the possibility of the existence of further illegalities may still exist. The High Court further noted in para 273 that the SSC had not been in a position to state that it had checked all the records so as to be definitive about the number of illegalities, and the state government had also accepted that there were widespread illegalities in the selection process. On 19th May 2022, the government of Bengal in the school education department issued an order creating 6861 supernumerary posts of teachers and non-teaching staffs for absorbing the wait-listed candidates, and directed that appointment letters to such wait-listed candidates shall be issued in terms of the recommendation of SSC, subject to the outcome of the pending litigation before the High Court. Now, this will be one of the issues, Lord, which I am concerned with, which I'll elaborate later, Lord. During the course of the hearing, this court has been informed that the petitions under Article 226 of the Constitution, petitions have been instituted before the High Court to challenge the order of the government creating the supernumerary post to accommodate the wait-listed candidates. By an interim order, the government order creating the supernumerary posts have been stayed.
So what is your stand? You want the stay to be vacated or what?
No. We did not appoint. What the High Court has done in this case is that separately, Lord, independent of these illegalities, they have put a question, Lord, to the state as to why these supernumerary posts were created. So with regard to that also, they have, Lord, issued a direction that a CBI inquiry should be done, how this order was passed and the entire.
Okay.
So with regard to that direction alone, which your lordships have stayed in this by this order. I'm not saying we did not appoint anybody except one candidate, which High Court had directed on humanitarian grounds. In this backdrop, the High Court by its impugned order has, while setting aside the appointments, directed that the OMR sheets available in the 3 hard disks must be uploaded on the website of the Selection Commission. Persons who had been appointed, A, from outside the panel, B, after expiry of the panel, and C, against the submission of blank OMR sheets, must return all the remuneration and benefits received by them to the state exchequer, together with interest at 12% per annum, failing which the outstandings would be recovered as arrears of land revenue. CBI shall interrogate all persons who had received appointments beyond the panel after expiry of the panel and after submitting blank OMR sheets if necessary by undertaking custodial interrogation. CBI shall undertake a further investigation with regard to persons involved in the state government who had approved the creation of supernumerary posts to accommodate the illegal appointments, if necessary, by conducting custodial interrogation. And 5, the SSC shall undertake a fresh selection process as a consequence of the vacancies which are declared on the setting aside of the appointments. Other consequential directions have been issued. Primary submissions which have been urged during the course of hearing by counsel appearing on behalf of petitioners fall under 4 broad heads. 1, the data on the basis of which the High Court has set aside the appointments of nearly 25,000 persons, including assistant teachers and those appointed to non-teaching Group C and Group D posts is suspect. The foundation of the exercise is the certificates under Section 65 capital B issued by Pankaj Bansal, a former employee of NISA Communications Private Limited, from whose possession the 3 hard disks were seized. In a selection process having such a large magnitude, cancellation of the entirety of the selected list, select list would be a matter of the last recourse. Where a segregation of the tainted candidates is possible, only such appointments should be directed to be discontinued. 3, the above consideration must apply to a fortiori in a situation where the petitions were filed nearly 3 years after the appointments were made, the directions to set aside the entirety of the appointments would have serious repercussions to employees who have served the state. 4, where the appointments which are tainted are capable of being identified, it was manifestly unjust for the High Court to set aside the entire process. On the other hand, it has been urged on behalf of the respondents who have supported the judgment of the High Court that both the SSC and the state government were not in a position to state the possibility of further illegalities can be ruled out. When a systemic fraud has vitiated the entire process, the High Court was justified in setting aside the entirety of the selection process. The submissions which have been raised on behalf of the petitioners would merit further consideration. The certificates under Section 65, capital B of the Evidence Act were issued as the CBI report notes by Pankaj Bansal, who is a former employee of NISA Communications Private Limited. The legitimacy of the certificate which have been obtained from the above individual would prima facie go to the root of the data which forms the basis of the judgment of the High Court to set aside the entirety of the appointments. From the material which has been placed on the record before the High Court by the SSC and the CBI during the course of its investigation, a further issue which would merit closer analysis is as to whether appointments which suffer from taint can be specifically segregated. If such an exercise is possible, it would be unfair to set aside the entirety of
Main issue, in fact, let's be very clear, this is the main issue.
that is the main issue, Mulad, except for the state which is concerned with that part.
That's the main issue.
Yes.
One issue is the material on the basis of which the finding is recorded.
But
There's only one certificate
But I must tell your lordship, Mulad, that there is a group of petitions, Mulad.
So are you supporting the
No,
proposition?
I'm not supporting this, but yes,
No, 1 minute.
the state
The
is
state of
supporting
West
the-
Bengal supporting the proposition, it's not possible to segregate the taint from the.
No, the state is saying that supporting this segregation, Mulad. We are saying that it can be, because CBI has not given several reports.
Let's,
Mindful of the impact of setting aside of a large complement of assistant teachers who have been recruited for both class, which would be the consequence if the impugned judgment were to be upheld as it stands. Assuming that a segregation is possible, the court would have to determine the modalities which would be followed for that purpose. At this stage, the court must be guided by the fact that by its order dated so-and-so, this court had protected the appointments which had been made subject to the direction to the High Court to expeditiously dispose of writ petitions, bearing in mind that notice is issued. Then some interim protections were given, which you'll also find in para 34.
yes,
In the meantime, an interim protection which was granted by this court by its order dated 9th November is continued, subject to the express stipulation that any person who is found to have been appointed illegally and is continued as a consequence of the present order shall undertake to refund the entire amount of salary which may be paid between the date of this order and the final judgment of this court.
just one clarification. This interim order also inures to the benefit of those where the numbers mentioned,
Illegalities have been specifically found.
yes.
Yes, that
16 and
covers
17,
them also. They are also continued, so, but with this stipulation that they will have to
they
refund
have to
everything.
cover 16, those covered by 16, in paragraph 16 and 17 is also, they're getting benefit of this interim order.
Yes,
Okay.
and they are in fact working also.
17.
Okay, yes, please.
Then the investigation by the CBI, which has been ordered by the High Court in clause 7 of its operation directions, will continue, but no coercive steps shall be taken. 36. This is where which state is concerned. The High Court has, by its impugned order, directed the CBI to investigate the creation of supernumerary posts at all levels of the state government. This court, by its previous order, directed that no precipitate action would be taken in pursuance of the direction contained in clause 8 of the operative directions of the High Court, which is reproduced below, which is this, Lord, that CBI will undertake further investigations with regard to the persons involved in the state government, approving creation of supernumerary posts to accommodate illegal appointments. If necessary, CBI will undertake custodial interrogation of such persons involved. Now, this expression to accommodate illegal appointments is incorrect. The order doesn't say that. It says it will to accommodate waitlisted candidates because there were already reports of Justice Bag's committee, etc., pointing out illegalities. So the state was worried a lot about the vacuum which will be created. So they created supernumerary posts for appointment from the waitlisted, and that is also subject to the approval by the High Court. And in fact, no appointment has been made. So this blanket direction saying that you investigate everybody who is right from the officers, right up to the cabinet, the posts have been created. And with custodial interrogation and all that. So our submission is that the division bench went too far ahead, which was unnecessary. Then para 37 stated that no appointment whatsoever has been made in pursuance of the order of the state government dated 19th May 2022.
You may therefore divide your arguments into two parts. One is with regard to segregation, and the other is with regard to the direction given in terms of paragraph 8.
So
You can divide your arguments into two parts. First, you deal with the segregation part, and then you can deal with 8.
As has been stated by your lordship in this judgment order which I have read out, and which is not disputed, that one, there was Justice Bag's committee constituted to investigate the irregularities. Then the CBI investigation when the OMR sheets were recovered from NISA. Then they were handed over to the selection commission. They also submitted their report.
After this interim order was passed, we have carried out the exercise and we have filed an affidavit on 2nd of August of this year, indicating name-wise the persons who we believe are, capable of being segregated, and the rest can be saved because there is 25,000.
That being there, let's first see the reason.
Yes.
Kindly have page 255 of the impugned order. In fact, please have 252 minutes. Because one of the issues was whether these OMR sheets recovered from NISA's officials, etc., is reliable, it should be proceeded, because that is the foundation.
No, one minute. We'll go to that later. You start this.
No, this is important. I'm not going into that issue.
Mr. Dwivedi, I'll tell you the reason why I'm saying so.
Yes, ma'am.
There's a misconception about 65B. 65B is only a mode of proof. The evidentiary value which will attach to a particular document, the weight will be attached to a particular document depends upon not the mode of proof alone, though they're connected, but to several other factors.
So I'm not going into.
Let's not go into that. So the second part, when we deal with the second part, it will obviously answer the first part.
No, I'm not at all not going into that issue because I'm not questioning, state is not questioning the authenticity and all those of the matrix.
There's a difference between the two. There's a huge difference between the two. Anybody issuing 65B certificate is only a mode of proof.
So what I'm
it's not dealing with 65B doesn't deal with and say what evidentiary value will attach to that document.
All that I'm trying to point out is that in this paragraph 307, just note it, I will not read it.
Okay,
What-
we'll come to that. Let's first read the reasoning. Therefore, I said.
High Court, foundation of my submission is based on this, namely, the High Court says that these are authentic, reliable and everything. I am proceeding on that foot. I'm not questioning this.
Okay, if you want to
I'm
read,
leaving
you can
it-
read that. If you want to, after having given that caveat, if you want to, please do
No,
that.
just have at page 253, last 5 lines. I'm not questioning this finding for the same. High Court says at the bottom of 252, factor,
Start from 307.
yes, the certificate dated 16th September 2022 issued by Mr. Pankaj Bansal relates to the data contained in the 3 hard disks adherence to requirement of section 65B in the facts and circumstances of the present case has to be adjudged on the conduct of the parties to the proceedings. All the relevant parties have admitted the contents of the 3 hard disks and acted on it without any demur. The Selection Commission has acknowledged manipulation illegalities in the recommendations and withdrew, cancelled the same. State has decided that the cabinet.
I take it that OMR sheets originals have not been recovered.
No,
They have been destroyed.
they were destroyed because.
Please. They have been destroyed. So original document is not available.
Not available because petitions were filed after two years long gap, so they were not available, which is correct. Now, all I'm saying is, and I'm relying on this, that once the High Court relies on the authenticity, valid.
Mr. Dwivedi, there is a difference between the two. 65B certificate will only say that what is downloaded from the hard disk into the hard form is what is stated or loaded in that server or the hard disk.
That's right.
What was loaded on the server, whether it's a true and authentic copy, is never given by 65B.
No,
That is never given by 65B.
no,
That's a question of evidence. There's a difference between the two. I'll give you one simple example. The call record details which we get are downloaded from a server. That downloaded is first captured when the calls are made. Then there is a blockchain effect. You keep on changing. When a person gives that certificate, he gives a certificate that as I downloaded from the server, this is the data which is there. But he cannot vouch for whether there was any manipulation or change in data.
but before it was downloaded. That's all it was. I'm not questioning, others will, learned councils will address on that note. I'm not going into 65B. What I'm saying,
Please wait for your turn.
I'm making a very limited point here that High Court has in the last 3 lines, factum, validity, legality, sufficiency, authenticity of the data has been proved by the conduct and actions of the relevant 12 authorities subsequent to the seizure of the 3 hard disks and after CBI had shared such data with the relevant authorities. So after recovering, then it was shared with the commission, other authorities, and therefore finally Lord, the High Court feels that this authority, these data can be relied upon to adjudge Lord, whether there has been enhancement of marks in it or not. All those findings are based on the first prima facie finding that this is authentic and we can be proceeded with. This is all the limited thing which I wanted to point out. Now kindly have Lord's paragraph 312 at page 255. In the factual context of the present, sorry.
ছটাকায় 1 কোটি কোটি টাকা ছটাকায় মাত্র ছটাকায় 1 কোটি ছটাকায় 1 কোটি কোটি ছটাকায় 1 কোটি
কিনুন ডিয়ার সাপ্তাহিক লটারি মাত্র 6 টাকায় আর পেয়ে যান প্রথম পুরস্কার 1 কোটি টাকা।
ছটাকায় 1 কোটি কোটি টাকা ছটাকায় ছটাকায়
ডিয়ার সাপ্তাহিক লটারি ভাগ্য বদলের দিশারি।
thing we want to know. Is there any rule or prescription in the, that when OMR sheets should be destroyed?
Yes, 1 year.
1 year is.
1 year. Okay. We are asking a question, Mr. Dwivedi, everybody is wanting to answer.
Anxiety. Brother.
Yes, please.
At page 255. The bottom para 312. In the factual context of the present proceedings, we have three options to explore, namely, dismiss the writ petitions on the ground of maintainability. 2, explore the possibility of segregating the valid appointments from the illegal ones. 3, set aside the selection made in the selection process in its entirety.
Now, as far as second option is concerned, we need not go through the judgments, we know the case law. So we can skip that.
Yes.
Segregation of the second option.
That's all right. The judgment cited
We know the legal position ratio, why should we read those?
only the earlier judgments.
Yes.
In the
But we have given
That's
it
all.
now.
Come to,
Para 320. Para 320.
yes, please.
The authorities noted above have observed that cancellation of a selection process without appointment being given therein stands on a different footing than a selection process where appointments had been granted. In the second category, courts must shift the grace from the shaft if possible. In the event it is impossible or highly improbable to shift the grain from the shaft, then the court may venture to cancel the entire selection process. Prior to embarking upon such an exercise, it must be satisfied that the selection process was tainted on the basis of cogent materials. There must be sufficient materials gathered through a thorough investigation that there has been illegalities in the selection process. The appointees had benefited out of the illegalities and were a part of it, and that the appointments made were contrary to law. In respect of the 4 categories of the selection process involved, written examination has been held. Written examination was in the form of OMR sheets. Original OMR sheets have been destroyed by SSC. Mirror image of the destroyed OMR sheets was required to have been preserved by SSC. CBI had seized the server of the SSC and did not find mirror image of such OMR sheets in the server of
Is
SSC.
this factually correct?
Actually correct.
Is this factually correct?
Mirror image. Yes.
Was mirror images of the OMR sheet preserved by the SEC?
Not preserved and not required.
1 minute. That's the second argument, but they were not preserved.
SSC is an authority within the meaning of Article 12 of the Constitution and have been enjoined with the task of undertaking the selection process. Last report of the CBI has stated that SSC appointed Messrs. NISA for the purpose of scanning and evaluation the OMR sheets. Messrs. NISA had engaged another organization, Data Scantech, to do so. It is unclear as to whether the new agency had merely scanned the OMR sheets or was instrumental in evaluating the same also or not. Chairman of the SSC, in response to a query, the court has stated that he was not aware of the engagement of Data Scantech in the selection process, and that in fact he became aware of such name only from the court for the first time. No material has been disclosed as to who authorized Mrs. NISA to engage Data Scantech or that such instrumentality was lawfully engaged by SSC.
So what is being held is this, factually, that SSC did not keep a mirror image with them of the OMR sheets. They had engaged NISA to undertake the evaluation of the OMR sheets. And NISA in fact gave it to
Data Scantech.
Data Scantech. They also did not do it.
Yes.
The three this which were recovered are from NISA or from Data Scantech? From Data Scantech.
NISA.
From NISA. NISA must have got that data from Data Scantech because they did it.
No, NISA took the data in its computer, then NISA must have given a copy
Correct,
to them.
correct. So 1 minute, please. So the data scanning or the OMR sheet scanning is done by data scanning as per you,
As per the finding, yes.
as per the finding given. And that data was then, or the hard disk with regard to that were given to NISA because NISA is the authorized by the SSC to undertake that. Yes, please.
Significantly, it is the claim of SSC that scanning of the OMR sheets had taken place at its office. If that be so, then SSC had knowingly allowed another organization to scan the OMR sheets, namely Data Scantech, who was not authorized at all. These raise questions as to the integrity, sanctity, and validity of the entire selection process, and giving to the root of the selection process, the evaluator of the selection process had been selected through a process which at best rooted in mystery, if not downright illegal. Then the conduct of the evaluator is such that it affects the validity of the process of evaluation itself. Significantly, Mrs. NISA had been appointed without an open tender. SSC had selected Mrs. NISA ostensibly on the ground of its being the lowest tenderer from amongst a chosen few who were asked to participate. The parameters qualification required to participate remains undisclosed despite a request being made in court to SSC. No explanation has been provided by SSC in course of hearing as to how and why such a course of action had been undertaken in identifying the instrumentality who was to scan and evaluate the OMR sheets. Documents that have been made available on record does not suggest that competency, efficiency, and whether Mrs. NISA has the requisite expertise to undertake such exercise was not considered by SSC at all. Letter of appointment of Mrs. NISA contains only 2 lines which requires Mrs. NISA to scan and evaluate the OMR sheets. No other terms and conditions of appointment have been specified. The appointment letter has been received by the one employee of Mrs. NISA from the office of SSC. SSC had destroyed the original OMR sheets ostensibly by keeping a mirror image thereof in its server. CBI did not find those mirror images in the server of SSC.
Did the SSC at any time say that they had retained the mirror images?
No.
They never said that.
They never said that.
Under the rules, are they required to maintain?
No.
They are not. But isn't it obvious they should be maintaining that?
Because
1 minute, Mr. Trivedi, that's the question. It should be asked. 1 minute. That's the question because you are also supporting that it's possible to decipher tainted from untainted. You see, the original paper is the OMR sheet. That's a fact. That's a primary evidence.
Yes.
If any manipulation is done on the main evidence or main paper, it will be only visible in the OMR sheet. OMR sheets, normally we have pencil marking, if I'm not mistaken, or pen marking.
Yes. Ball
pen. Now what happens is, there are cases in which people don't fill up the full question paper. They don't give all answers. So they have possibility of putting those pen marks. You fill up the holes, you block the holes, or that's a possibility which happens. There's also a possibility of changing the OMR sheet. I don't know whether each OMR sheet had a number. We don't even know that. Was it numbered or not numbered?
So that's not been a matter of inquiry.
No. 1 minute, please. We don't even know how did the checking take place, whether the name of the candidate was camouflaged and the top portion was erased and given for when it was done for checking. Normally checking is very simple. You just scan it through the computer and they, with your question answer sheet, and it scans very fast. Doesn't require, it's AI, completely AI. It's not human driven. There's no human checking, except where you want to check. Sometimes what happens is students mark 2. They can mark 2 also, or sometimes you find it's difficult whether it's marked or not marked. Some hole, the marking by pen is there or not there. the issue would be because the originals are not available. So there is no way we can authenticate whether the original OMR sheets were identical to the scanned OMR sheets which are available on.
So the entire inquiry has.
But then how do you, if this is the position, then what is the fault in the finding of the High Court?
No, the submission is this, Lord, that High Court proceeds on the authenticity and legality and validity of the OMR sheets.
Oh, no, they do not. Please understand one thing.
So that's how, Lord, the.
No, Mr. Devedi, that's not, that's why I said there's a difference between 65B certificate. 65B certificate only says that the hard copies which have been downloaded or which are downloaded are the copies, is the copy of the.
No, I'm not on 65, I'm not on 65B.
But it will not prove that what is scanned and stored in the hard disk is the original of the OMR sheet.
But that's how the High Court proceeds. High Court, Lord, takes the OMR sheets and gives it to the SSC and others and find out, Lord, on the basis of comparison. Because the marks obtained by the candidates selected and appointed are known. Now, based on the OMR, High Court finds not that a person who got 0 to the OMR sheet recovered has got higher marks. So that's how they say that marks have been interpolated for that candidate.
Okay.
So the basis of the
Anyway,
entire.
we put that question. Let's see what answer we get.
Yes. My respectful submission is that the
Okay,
basis.
let's read further from 325.
Yes.
The SSC destroyed the original OMR.
Ostensibly by keeping mirror image thereof in its server, CBI did not find those narrative stand of the SSC state and the board had added to the burden. The entire selection process is shrouded in such mystery and in such layers that it is difficult to fathom the quantum of illegalities performed. That illegalities had vitiated the selection process of Mrs. Naisa stands established. We have discussed the illegalities so far discovered vitiating the selection process in course of our discussions herein and will tabulate the same hereafter. The plausible inference from the materials made available on record and the conduct of the relevant party is that the entire machinery was devised for the purpose of effectuating a scam which will be hard to discover and even if discovered difficult to prove. Appointment of Messrs. Naisa, destruction of original OMR and non-availability of are some of the crucial points in the fraud that came to be perpetuated. Now, this finding with great respect, after 2 years and 3 years, if the petitions are filed, and the rule doesn't require beyond 1 year, so there's no requirement, that it should be preserved beyond that point of time. And that is taken as a basic factor, of holding this fraud. As noted above, in the course of hearing all these matters, SSC, state and board have perseveringly non-cooperated so that even the possibility of trying to separate the grades could be rendered nugatory. What has been produced by the selection process is not a serial comprising of grains and chaff capable of segregation, but a product unfit for human consumption. Fraud perpetrated is deep and pervasive. Any attempt to shift the proverbial grain from the chaff would be an unprofitable exercise prolonging the agony and would put premium on dishonesty. Now, based on CBI, the report, the whole thing is proceeding and CBI has pointed out each and every candidate on what respects, on what grounds his appointment is vitiated. In the facts of the present case, blank OMR sheets have been submitted and such candidates have been shown to have scored sufficiently higher numbers so as to be recommended for appointment.
Is this factually correct? 29.
No, some people who have been appointed.
No, I'm not on that. is it factually correct that there were some blank OMR sheets and these were shown to have, the candidates were shown to have secured higher marks?
This is not correct, but what has happened is that marks have been increased.
Marks have been increased by
Somebody who got zero.
one. The OMR sheets on correction, on checking were found to have X marks, which was say 50, but the marks which are
Marks in
written
the select list are higher.
higher. But it is not that blank OMR sheets were.
Nobody, even
filled up.
CBI doesn't report this.
Okay.
There's no basis for this. The exact nature of candidates fraudulently given the appointments cannot be identified, more so in the attitude of non-cooperation. There are other manipulation illegalities in the selection process which has come to light. Again, exact number of persons who have benefited out of such manipulation illegalities in the selection process cannot be identified in its entirety. Some have been identified. Identification of some is such that in respect of Group D, 48% has been found to be obtained by manipulation illegalities. The percentages of manipulated illegal appointments across the other three categories are on a reducing scale compared to Group D, but nonetheless sufficiently significant to question the validity of the entire process.
Just for the, just we pause here for a little minute. Now come to the order of 7/5/2024.
Yes.
The table at page 13. Paragraph 13 and 14.
Para 13 at page 11 was, or the quoted para 13?
Yes, we can go to the table itself.
From the.
Sorry, not paragraph 13, 16 and 17.
14.
Paragraph 16.
Yes, or yes, we can, paragraph 16 and 17.
17 as the.
On 15.
On comparison, just 1 minute. Paragraph 12, which is quoted there in italics. From the
On a
CBI report.
comparison of these actual genuine OMR marks with the OMR marks available in the wbssc server shows that there is
1
manipulation.
minute now, what do you mean by this? On the comparison of the actual genuine OMR marks available
He is referring to not to the OMR sheets recovered from NISA.
recovered from data,
Yes,
not NISA, recovered from data,
yes.
but available
The
with NISA.
former employee of NISA who was at that relevant
Fine.
time an employee.
Okay, fine. Then the
That's
marks
the basis.
available on the WB.
The select list where the marks are contained. So they are trying to say that marks in some of the candidates are
About
manipulated
700,
and shown higher.
they were shown higher.
Yes. And how many are there? 952 number of candidates of 9 and 10, 907 candidates of so-and-so, 3481 of Group C, 2823 of Group D. So there's a complete identification by CBI.
That's, we are aware of it. We are not,
That during the course of investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons and officials of NISA. These emails contain lists of candidates whose OMR marks were found to be increased in the server of the commission. So the emails are there to corroborate to know that who are those candidates. Besides this, emails have been exchanged.
Listen, there's a good insurance
A good insurance policy. Let's ask AI. A policy in which premium payment is limited but provides income for lifetime.
LIC Jeevan Utsav.
Wow! Lifetime celebration. With LIC's Jeevan Utsav, your future is set.
7 candidates for class 11, 12, 3481 candidates for Group C and 2823 candidates for Group D. Apart from the above report of CBI, the impugned judgment of the High Court contained in para 240 a reference to the fact that SSC had submitted statistical report of the 4 selection processes tabulating the alleged irregularities. The tabulation is produced below for the convenience of reference. So 2 authorities both have been, and they have made the basis.
that's 1 minute. The figures given in this table,
Yes, for
as per
assistant
the
teacher 9 and 10.
SEC, as per the SEC itself, where there were irregularities committed, are different from the table given by the CBI.
So CBI found
One
more.
minute, 1 minute. So the CBI says is where OMR sheets available, OMR marks available in the OMR sheets, vis-a-vis the marks which were available on the wbssc server. The manipulation was in 752 candidates,
Yes.
907 candidates, 3481 candidates,
Yes.
and 2823. And if you turn to the list which is given by the SSC, where they say that there were irregularities noticed in tabulation,
Yes.
there is a OMR issue in 808. I don't know what is the OMR issue.
OMR issue, Millard, is where the OMR marks and the actual marks in the Pankaj Bansal's 3 discs are not tallied.
Okay. Then there is 771, 783 and 1741, whereas the details given in the CBI are much higher.
But there are small differences. We have reconciled it subsequently.
There's
More or less same Millard will come if all the three.
no, that table doesn't tally. This one which are found by the CBI, they don't tally with the OMR issue. Then there's a rank jumping. And then there's alleged irregularity. What do you mean by alleged irregularity?
That's the sum. OMR plus rank jumping.
That's the sum total of the two?
Yes.
Extra is the part. Row, Millard, is the same.
Okay, fine. And then there is the case where additional or excess appointments have been made.
Yes.
Irrespective of the marks obtained.
Who are beyond the list.
Beyond.
So what I am trying to respectfully submit, Millard, that the two authorities have been able to
Look,
identify.
now the factual situation as it is emerging is this. SCC did not maintain the mirror image. The original OMR sheets are not available. The only evidence with regard to the OMR sheets which are available is in form of scanned OMR sheets, which was done by data and then given to NASA. There is evidence to show that the marking or the marks obtained as per the scanned image of the available with data is different from the marks which were entered in the server of the West Bengal Civil Services. There is also, as far as appointment of NASA is concerned, there are irregularities stated. The scanning itself, the process followed, there are irregularities stated. Because data did the scanning purportedly in the office of the SSC. But we don't even know whether the scanned images which were done by data, there are the actual scanned images which were recovered in the form of the hard disks. 1 minute, please. We don't even have that because 65, please. 65B certificate will not say so and will not be able to authenticate. 1 minute, please. Because then you had to lead evidence to also show that the hard disks which were recovered by the CBI were the actual hard disks which were installed in the machines or the scanners.
Yes, that is established.
That is going to be difficult. That's going to be very difficult for you to establish. Number two, the metadata in then those scanners will have to be examined to find out whether there was any change in those. Because metadata will give you the date on which it was scanned and uploaded.
The CBI has done.
1 minute, we'll know from the CBI,
Extensive-
we'll ask the CBI whether they have done that, we'll know exactly.
They have done
One
extensive.
minute. Now, please look at these are the issues which the High Court failed. If these are the facts on record, we cannot now segregate tainted from the untainted cases. Now, meet all these arguments which have been addressed in your own way, and other petitioners can also meet that argument in their own way. We'd now like you to hear you on that, and
So
then
first-
on the second part with regard to the CBI.
So the record which is with.
No clear finding.
Clarification we require. The details of all OMR sheets were found, details of all OMR sheets of the candidates who had appeared were found in the server, or there was some missing.
So I think.
There seems to be no finding that these three hard disks.
everybody to inspect.
Please hear what I have to say, then you answer. There's no finding anywhere in the judgment that these three hard disks which were recovered contain the OMR data of all the candidates who had applied and appeared for all 4 categories of posts. They did contain, with those 3 hard disks contain the entire data. There's no finding available anywhere.
Just to satisfy the court's
The
query,
CBI also doesn't say so.
that the honorable court directed.
Says, Pankaj Bansal, from whose custody these 3 disks are obtained, says all data, including the scanned images of His saying so is not sufficient. Where is the comparison with your OMR evaluation marks data, which is at least available still with you? On that basis, do you say anywhere that entire data is available? You don't say so anywhere. Very small discrepancies there, nothing.
We'll hear you, we're not saying. And one more thing which has been mentioned in the High Court judgment, that there were some blank OMR sheets.
Yes, fact.
Is that correct?
Yes.
Were there some blank OMR
The
sheets?
report
also?
doesn't, CBI doesn't say that.
That is the affidavit of SSC itself, I show.
That is a line also.
So these are the issues, you have to now meet those issues.
No, but with respect. to
Another
facts-
important,
Rather not issues, rather these are facts which.
Yes, yes. And,
another important aspect, may I clarify, just for,
Let them finish, then you will have it.
deeply obliged.
So, Lord, in greater detail, Lord, this aspect will be dealt with by the commission, Lord, but I am, Lord, submitting, Lord, on a narrow footing, namely, that extensive inquiry had been done, one by Justice Bag's committee, Lord, which was appointed, the other, Lord, by the.
Tell me why did you create supernumerary post? Why did you?
Yes.
What is the purpose of creating that?
Supernumerary post, Lord, because after Justice Bag's report was received,
When was that report received?
just, which, in April 22.
The report was received after the report said there were irregularities?
Yes, they also found some irregularities, but not as extensive as the CBI report. It was on a narrower. Based on which, Lord, 269 appointments had been invalidated, which then came up in the interim stage to this court. Your Lordship stayed the.
So they found there were irregularities committed. So in order to deal with that situation,
So, Lord, we.
instead of weeding out the persons who had been appointed illegally, you said, okay, create supernumerary post.
For appointing the
No, but
wait list.
Mr. Devedi, tell me
Wait-
one thing.
wait
If you find irregularities committed, will you not throw them out first?
No, not for them,
But 1 minute.
for
But-
waitlisting.
1 minute. The moment you create supernumerary posts, you are then ensuring that the persons who are tainted and wrong, who should not have been appointed, their appointment should continue.
No. The order specifically says for appointment from the waitlisted candidate.
Correct? Well, the reason is this, that you don't want to throw out the tainted candidates.
No, Lord, sir, that is not up to us because High Court says, Lord, they have to be non-ordinary. We can't retain them.
Okay.
We can't retain them. And we specifically said that this is subject to orders of the High Court. And we did not appoint anybody. Equally, more so, my lord, this order was challenged in some other petition which is still pending in the High Court, where an interim order was granted staying that order. And in these batch of writ. I'm sorry, but-
Hear you last on that. Let's hear the others. We'll hear you last on that. For second one. We'll hear you on the line.
വേറൊരു സന്തോഷ വാർത്തയുണ്ട് പറയാം. ഈ മനുഷ്യനുണ്ടല്ലോ നിങ്ങളുടെ കെട്ടിയവൻ നമ്മുടെ കുടുംബത്തിനകത്തുള്ള സകല കാര്യങ്ങളും താഴത്തെ ആ സെക്യൂരിറ്റിയോട് വിളമ്പിയിരിക്കുന്നു.
ഇതൊക്കെ പുറത്ത് പറയാൻ കൊള്ളാവുന്ന കാര്യങ്ങളാണോ? ഇനിയിപ്പോ ഇതൊക്കെ അവന് പറഞ്ഞിട്ട്
അയാൾ അറിഞ്ഞു കഴിഞ്ഞാൽ സെക്യൂരിറ്റി സുഖം അറിയും, സുഖം അറിഞ്ഞാൽ കെയർ ടേക്കർ അറിയും, കെയർ ടേക്കർ അറിഞ്ഞു കഴിഞ്ഞാൽ അസോസിയേഷൻ പ്രസിഡന്റ് അറിയും, പ്രസിഡന്റ് അറിഞ്ഞു കഴിഞ്ഞാൽ ഹോൾ ഫാമിലി അറിയും. പിന്നെ നമ്മൾ ജീവിച്ചിരുന്നിട്ട് വല്ല കാര്യമുണ്ടോ അമ്മേ?
അയ്യോ, ഇനിയിപ്പോ എന്താ ചെയ്യാ?
ഇനിയിപ്പോ ഒരു വഴിയേ ഉള്ളൂ, നമുക്ക് പ്രാർത്ഥിക്കാം.
Port one new is there. Port one new. That is the password for the name. This is the password.
Continue, please.
Kindly look at two paragraphs, not 229 and 230 of the High Court judgment. The point which I'm making is that CBI has made an inquiry, looked into the OMR sheets, discrepancies, how many are beyond the select list. The Assistant Secretary of SSC has submitted a report in the form of an affidavit in response to the order dated 13th of January 2023, where the number of vacancies declared in Group D posts were tabulated. Number of candidates, I'm so sorry.
Go ahead. I've already
The
read
number
both
of candidates empaneled and the number of waitlisted candidates were also stated. Significantly, it has been stated that manipulated OMR sheets supplied to SSC by CBI were 2819. Another affidavit in SSC has stated that NYASA was an agency appointed by SSC for the purpose of assessing scanning with regard to the third regional levels test 2016 for appointment of Group D staff after receiving the OMR sheet and in compliance with the orders of the court. SSC had checked the OMR sheets and other data supplied by CBI in the form of hard days, whereupon it appeared that the marks of 2819 OMR sheets were lesser than the marks of the candidates as were kept in the server of the SSC. Out of 2823 candidates in which marks had been manipulated, enhanced 1911 candidates had been wrongly recommended. Then 231 similarly, so on each aspect on a comparison, a specified number of candidates identified were pointed out, the number was pointed out, and that has been found in the tabulation. So both CBI and the SSC, my lords, after getting the OMR sheets, have come out with figures, exact figures. And that's how at page 240 is the table which finds mention in the interim order.
Okay.
All that they say in 242 is that SSC did not discount the fact that possibilities of further illegalities exist. Now, nobody can discount that, but the point is that after extensive inquiry, if specified number of candidates identified have been mentioned, then why should we throw out 25,000 people, my lord, against whom there is nothing? Keeping in mind that the petitions have been filed after 2 years and 3 years.
Number 306.
Yes. CBI in its reports have detailed how Mr. Pankaj Bansal, along with persons in the control and management of Messrs. NISA, kept the mirror images of OMR sheets and were providing data as called for from time to time by SFC. SSC, in fact, had responded to Right to Information Act applications providing OMR sheets to individual RTI applicants, claiming that such data was in its database. Affidavits filed by writ petitioners have borne out that such facts. SSC had provided Anindita Behra, writ petitioner, a copy of OMR sheet in January. Sorry?
You don't get interrupted. I've already read this paragraph. What is being pointed out in 306 is the SSC had taken the stand that they have the mirror images with them. In the affidavits which were filed and when the OMR sheets were supplied, it says the affidavits filed by the petition.
24 also.
Sorry, Viraj?
In January 24 also.
Yes.
That the database was stored in SSC database, was supplied with a sheet on so-and-so from the SSC from its database. And again, from its database. So if they were giving data, the OMR sheets from their database, where did their database of mirror image go?
That's not our affidavit.
And you come to this, that's the one finding, and then you can come to page 305, which is the report, which quotes from the report. Let's read that part also.
I can place the whole of
These are your affidavits filed by the SSC. And the SSC in the response to the Right to Information Act said that OM sheets to individual claiming that data was in its database. That's the finding recorded. The SSC had in the RTI application said that the OMR sheets copies are available in its database. And the affidavits filed with them again say that the OMR sheets are being given are from their database. Whereas now the stand taken by the SSC is they don't have any database of the OMR sheets.
So my learned friend will explain this closer.
Okay, now come to page 245, 305.
Para 305. CBI has filed several reports in these proceedings. In its report dated 5th February 2024, filed in compliance with the order dated 24th January 2024, passed by us, it has stated as follows. that during investigation, it was revealed that the West Bengal Central School Service Commission, hereinafter referred to as Commission, had awarded a work order to Mrs. Nisa Communication Private Limited for scanning and evaluation of OMR answer sheets pertaining to the selection tests of Group D, Group C, and teachers. Investigation has established that Shri Puneet Kumar was the then director and Niladri Prasad was then vice president of the said NISA during relevant period. It has been established during investigation that Shri Niladri Prasad was in charge of operations in respect of recruitment examinations conducted by the Selection Commission and frequently visited the office of the Commission to attend the actual operation part and did the requisite liaison on behalf of agency for necessary compliance of instructions given by Commission. Shri Puneet Kumar, being director, mainly looked after the financial affairs of the agency and represented it on record. Investigation established that scanning of OMR sheets was undertaken by said NISA at the Commission office at Acharya Sadan under direct supervision of Shri Niladri Das and in presence of the Commission officials. It has been further established that Mrs. NISA Communication Private Limited had further given work order with respect to scanning and the original OMR to Messrs. Data Scan Tech Solutions Noida, who remained present on the premises of the Commission for the scanning work. After completion of scanning, the processed data in the form of scanned image of OMR, scanned data, etc., were handed over by Data Scan Tech Solutions to NISA, who took the same to their offices located at Noida in digital form, leaving the original hard copies of OMR sheets in the office of the Commission, handed over the answering keys in respect of all subjects to NISA for evaluation. That while scanning,
Just one. Yes.
So then the next two paragraphs, they are just describing how they proceeded to recover the data. That while scanning the original OMR sheets by Messrs. Data Scan Tech Solutions on behalf of NISA, files were generated containing scan number so-and-so. So that a sample of the DAT file generated during scanning of the OMR sheet is cited as an example below. Responses of candidates in the OMR is appearing as response code in alphabets while it indicates end of one OMR sheet. That two such DAT files were generated since scanning is done twice to avoid technical error. Thereafter, a final DAT file is prepared, which is called a clean data file. After receiving the answer keys from the Commission, the same is compared with the final data, and a DBF file is generated having the score of the candidates. That during investigation, server database of the Commission was seized by the Central Bureau of Investigation containing all the data pertaining to selection tests of Group D, Group C, and assistant teachers. That during investigation of the case, 3 hard disks were recovered on 15th and 16th September 22 from the resident Pankaj Bansal, ex-employee of so-and-so. The certificates of Shri Pankaj Bansal were obtained in triplicate with regard to genuineness of the data contained. That during investigation, data files contained scanned OMR sheets, DAT files, etc., pertaining to aforesaid Commission recruitment matters were also seized from Data Scan Tech. During investigation, the hash values of the data files of Scantech were matched with the hash value of corresponding files recovered from the hard disk seized from Pankaj Bansal and was found to be matching, which establishes that the data contained in the 3 hard disks recovered from persons were not contaminated. This is important to listen. That a similar exercise of matching the data available on the hard disk of Pankaj Bansal with the data seized from the Commission was done during the course of investigation, and it was found that there were mismatch between the two inasmuch as the written marks awarded to candidates as available on the server of the Commission had been increased to qualify undeserving candidates. This mismatch establishes that manipulation in marks of written examination in the case of many candidates was resorted to and such candidates were identified. The comparison of these actual genuine OMR marks with the OMR marks available in the server shows that there is manipulation in 952 numbers of candidates, 907, and these figures the lordships have seen. That during the course of investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons, and officials of NISA. These emails contained list of candidates whose OMR marks were found to be increased in the server of the commission. Besides, this email have been exchanged between the staff of NISA themselves containing manipulated data of candidates. This shows complicity of officials of NISA in this conspiracy. That during investigation, it emerged that during 2019, Shri Niladri Prasad left NISA and started his own business in name and style of ND Info Systems, Noida, and was engaged in the business of data processing in line of Mrs. NISA. The said Niladri Prasad poached Pankaj Bansal, Kuldeep Singh, Anoy Saha, Muzammil Hussain, and others support staff from NISA. It has emerged from investigation that before leaving NISA, Niladri Prasad and his staff have retained all the data pertaining to recruitment examinations, including data group C, so-and-so, and teachers with them. Even after leaving NISA, Niladri Prasad, Pankaj Bansal, and Muzammil Hussain kept providing assistance to Commission in matters of RTI on the basis of data of NISA, which was manipulated and also hosted in the Commission server. This also establishes that Khas, Bansal, and Hussain who were involved in the entire scam, it was in their knowledge. The data has been manipulated and therefore they continue to extend assistance solely to avoid detection. Investigation revealed that Commission has destroyed the original MR sheets and the scanned images of original MR sheets in the year 2019.
1 minute. This is important. This says the Commission destroyed the original images, the original MRs and scam images of OMR sheets in the year 2019. So the Commission had made scan images of the OMR sheets.
Yes.
But there is no requirement to be retained for all time.
That's something separate. I'm not on that. We are not on that. But there were scanned images of the OMR sheets which they had retained.
Yes, the original OMR sheets and both were there, according to this report.
Leads to an inference that...
Which again leads to an inference that the same were destroyed to keep the matter under wraps. That investigation establishes that as a reward for doing aforesaid manipulation in the OMR score, Messrs. NDISPL of Niladri was provided work for recruitment of teachers in upper primary conducted by Commission. Apart from this, many other recruitment works were also assigned to Niladri Das by the government of Bengal. Various lists of candidates related to upper primary were communicated to Niladri Das in Sinha. Sharmila Mitra were found in the email of Niladri Das, which shows his criminal conduct. The result of comparison of these records collected from data Scantech with that of hard disk seized from Pankaj Bansal. A, as discussed in the preceding paragraphs, the hard disk recovered contains the marks of written examination, typing tests, etc. This marks, when compared with marks available in Commission server, resulted in the identification of candidates whose marks of written examination, typing tests were manipulated. Messrs. Data Scantex made the initial scanned images. These scanned images were given to NISA. Pankaj Bansal retained a copy of the scanned images. That in connection with candidates of class 9 and 10, 11, 12, scanned images of OMR sheets as collected from Data Scantex solutions pertaining to the alleged candidates whose OMR sheets were found manipulated were matched with the scanned image.
Now, this also shows that there was OMR marks were found manipulated were matched with the scanned images available on the hard disk and the same were found to be identical.
Yes.
So 1 minute. What do you mean by this? The contention of the candidate so-and-so, the scanned images was as collected from so-and-so pertain to alleged candidates whose OMR sheets were found manipulated were matched with the scanned images of.
So data Scantrack and the hard disk of the Bansal,
Okay.
both are matching.
The response string of the candidates.
The response string of candidates pertaining to 9, 10, 11, 12 as recovered from data Scantrack matches with the response string available in the hard disk seized from Pankaj Bansal. On the basis of this response strings, the actual genuine OMR marks of 9, 10 were determined. The comparison of these actual genuine marks with the OMR available in the commission server shows that there is manipulation in 952 numbers of candidates of 910 and 907 candidates of so. The response string of candidates pertaining to Group C, Group T as recovered from Messrs. Data Scantrack Solutions matches with the response string available in the hard disk seized from Pankaj Bansal. On the basis of these responses strings, the actual genuine OMR marks of Group C and Group D.
For the corrected answer. The suggested corrected answer. That's a response string.
The marks as they
Is that
exist.
correct? Or it stands for something else?
What is it? I should know. So the answer sheet and this are both matching.
Okay.
The key answer.
The key answer, the correct key answer is the response string. If the response string is the key answer, correct key answer.
Individual answer. Response string, it may not be 100% correct. I asked my briefing counsel yesterday, we are private candidates. When you answer, they put a line like this to your dots in the OMR sheets. For example, AB.
Okay, they put that line
They join
so that nobody can change it.
that response string is then fed into some evaluation software. And that is what a response string, as explained to me.
No, but the response string is not put by the candidate or is put by the.
No, not by candidates. Not by candidates. That is not by candidates of evaluation.
Let's say evaluation, it's a computer AI generated.
What they have explained to me.
Okay.
The board has, but I asked them the same thing yesterday, what is the response string? And that other thing which was matched, that data frequency, is they explained to me that every file which we read has a particular frequency. And so,
that NISA was using people from an organization called DataScan to sit in the office of SSC and do the actual job, Milord, was not brought to the attention of the SSC at any stage, is what we have stated. So, Milord, as far as we are concerned, everybody we dealt with was NISA, was either a person employed by NISA or authorized by NISA, Milord, but they were all NISA. Now, NISA had mirror images. So, my lord, in the initial stages, when people made RTI inquiries, we obtained those mirror images and gave answers. But, my lord, subsequently, when my lord, it became clear that this should be kept separately, my lord, we did not give any such answer. It is not an affidavit of the commission that states that we maintain mirror images. 24th January is not an affidavit of, my lord, the commission. The commission has filed, my lord, 4 affidavits, the dates of which I'll give you, lordship, my lord. 24th is not.
Not an affidavit, your communication to that.
That's right, my lord. So therefore, my lord.
That you said that it is from your database.
So therefore, my lord, the database of NISA was also taken into consideration.
Your database.
Yes, yes. Because, my lord, they were authorized to do this job, my lord, on our behalf. So then, my lord, when the discrepancies arose, my lord, of, my lord, our server, which does not contain, my lord, any mirror images.
5 to 27 lakh candidates in each category.
22 lakhs candidates. Millard, I think 22, Millard. May not be 26, but there were 22 lakh candidates.
In each
or all together?
There are 4, Millard, posts here. There are 4 categories of posts. One is, Millard, up to 10, then 11, 12. Those 2 are, Millard, teaching posts. And then, Millard, there is Group C and Group D, which are, Millard, non-teaching posts.
So we wanted to know whether there were 27 or 22 lakh candidates in each category or.
No. All together, Millard. What this batch, this entire batch, Millard, we are dealing with.
22 lakh.
At 22 lakhs, Millard, examinees. Approximately, Millard, there would be. We can give exact figures also, Millard. The figures are maintained.
And the names of the candidates were erased or what?
No. Nothing is erased.
No. In the OMR sheet, the name of the candidate.
In the OMR sheets maintained by NISA is a scanned image.
In that scanned image, the name of the candidate is mentioned?
No, because, Millard, that is, Millard, the answer sheet. They would not write the name of the candidate on the answer sheet.
There'll be roll number?
There'll be roll number, Millard, and Millard
There'll
certificate.
be roll number mentioned there?
Barcode, yes. Roll number, barcode, all that is mentioned.
Barcode or roll number?
Millard, I think, Millard, roll number definitely is there. There may be a barcode also. Codes, Millard.
QR code.
Yes, QR.
We have the OMR sheet, so the names and signatures are there,
Everything.
And roll number.
Millard,
OMR sheets are there?
yes.
Blank, we were publishing their signature as server. They were giving it.
And not only, they published the server.
Many to plus.
Millard, page 246 of the judgment gives an idea, Millard, because there, Millard, the CBI, Millard, has given the report, Millard. Page 3, para 305, 245. Your Lordship has seen, Millard.
They have seen that.
Barcode, roll number, venue code, booklet, and Millard, just before that.
फॉरेक्स ट्रेडिंग अभी
एक ट्रेड में 6 सर।
प्रसिद्ध पहले सेफ्टी वरना क्लीन गोल्ड। अनऑथराइज प्लेटफॉर्म पे फॉरेक्स ट्रेडिंग यानी नुकसान, धोखाधड़ी और कानूनी कार्रवाई का डर।
मतलब नुकसान की हैट्रिक। इसीलिए आरबीआई वेबसाइट पर जाएं, ऑथराइज्ड लिस्ट जांचें। आरबीआई कहता है
जानकार बनिए, सतर्क रहिए।
सारे गरीब एक हो जाए तो पूंजीवादियों को हिला सकते हैं। इवन बाबा साहब अम्बेडकर सेड सेम थिंग।
Scan number, barcode, etc., etc.
Yes, please.
No, that is before. 1 minute. Para 289, Millard.
But normally, tell me one thing.
Yes, ma'am.
When you scan a data, then shouldn't you be maintaining the scan data yourself before you give a copy to the other side for the checkers to verify that? You normally, what will you do? You'll keep a data with yourself. Because once you scan, then the marking is done immediately. There's hardly any time gap between marking and scanning.
Lordship. Millard, the page 236.
The marking and scanning was done simultaneously.
Yes, by NISA itself, Millard.
So then you should have retained everything with yourself.
Millard, we are.
Look, please, it's very simple.
Yes.
Marking and scanning is done simultaneously.
Yes.
So then you retain the data with yourself.
Millard, we retained, Millard. What we retrieved in the server is, Millard.
No. What you did not retain, what has been found is with NASA and data.
Not data scan. Data scan does not come into the picture. It has come from NISA.
He separated himself after. But later. When the scanning was done, that data, the person of the person who's Pankaj Bansal was an employee of NASA
Yes.
But was he working with, or he had?
He was working for data scan and, but my lord,
SSC doesn't know anything.
All right,
Let us put it very clearly.
let me place, my lord.
Just one.
Para 33.
Then you should have retained that data with you. After all, it's.
As I
just
said, my lord, I
a-
can only assist post facto, my lord. Whatever your lordships decide, my lord,
You
I
have
can
you have
only
made your
assist
stand
post
very clear.
Yes. No, my position, my lord, that